in HEDDEN versus ZOLDCO.
May it please the court, Chuck Buford here for Mr. HEDDEN. Judge, Your Honors, we are here on...
Mr. Buford, would you like to reserve any time for
Yes,
rebuttal?
yes, Your Honor, 5 minutes, please.
Okay.
So we're here, Your Honors, on our appeal of a non-final order denying our motion to compel arbitration of a 3-count complaint which requested declaratory relief regarding whether compensation was owed pursuant to a compensation agreement which clearly requires arbitration. By way of background facts, Your Honors, my client sold his business to the appellee, ZOLDCO, in October of 2012. As part of that conveyance, the parties entered into a compensation agreement which provided for the potential of additional compensation being paid to my client if certain benchmarks were met over time, an additional $2 million if certain profits were generated over time. That agreement required arbitration if there was any dispute. Simultaneously, the parties entered into a non-competition agreement. And that agreement has a provision which says venue of any action related to that agreement shall be in Hillsborough County Court. A year after the parties entered into the agreements, my client voluntarily terminated his employment. 5 years after that event, in May of 2018, my client made demand for payment of the compensation under the compensation agreement. In response to that, ZOLDCO files this lawsuit, a 3-count lawsuit, effectively preempting our claim for compensation. They file it in state court, a multi-count complaint, which basically, and I'm going to go through each specific count, relates solely to the issue of whether compensation is due or not. That's what the gist of this case is all about. Going in reverse order, count...
Well, you said solely, and maybe go in the other order. The first count is not solely about whether, as a matter of fact, it's probably not at all.
What I'm saying is the ultimate remedy that they're seeking, even in count 1, is to avoid payment of compensation. Yes, count 1 involves the non-compete agreement.
Do we evaluate, I mean, does the Supreme Court's decision in Seifert provide us with the rubric under which we evaluate the arbitrability of each of these claims?
Yes.
Okay. Now, Seifert says the mere fact that the dispute would not have arisen but for the existence of the contract and the consequent relationship between the parties is insufficient by itself to make one a claim arbitrable under a broad arbitration clause. It seems to me that's what you're saying about count 1, right? You're saying we wouldn't be litigating this breach of this deck action on the non-compete but for my client's demand for money. And I mean, that seems to me to be exactly what Seifert says isn't enough.
Well, I'm saying that the provision for demand for whether money is owed or not is not found in the non-compete agreement. If you look to the compensation agreement, which there's a provision, paragraph 5.5 in the compensation agreement, not in the non-compete agreement. You have to look to the compensation agreement for the forfeiture provision of the compensation if there is a violation of the non-compete. So what I'm saying is that the non-compete by itself doesn't get you to a forfeiture of compensation. You have to look...
But that's not what count 1 argues. Count 1 just says...
It's in a vacuum.
The non-compete's been violated. We want a declaration.
Right. It's in a vacuum.
Right.
That's all they're asking for. They don't ask for injunctive relief. They don't ask for damages. Right? And then you go to count 2, and count 2 says, if there's a violation, we shouldn't have to pay you compensation because paragraph 5.5 of the compensation agreement says we don't have to do it. So my point is that count 1 is simply it's a defense of the obligation to pay compensation. That's my argument as to count 1. Counts 2 and 3, to me, are I don't even see a credible argument that they don't involve the compensation agreement, that there's not arbitration issues clearly involving both of those counts. So counts 2 and 3 have to be arbitrated. What the trial court did, though, in fact acknowledging that the issues of compensation should be arbitrated, he basically said, well, I'm going to look at count 1 first, and we can maybe come back later as to counts 2 and 3. That's what's in the judge's order. But by doing that, he's effectively has us litigating right now counts 2 and 3 when they have to be arbitrated. So counts 2 and 3 have to be sent to arbitration. That's our position. Now, I will concede count 1 is a closer call. I mean, there is definitely a provision in the non-compete agreement that says venue has to be of a dispute regarding the non-compete agreement has to be in Circuit Court, Hillsborough County. The problem is, okay, it's a close call. You're looking to both agreements, and there's the whole doctrine of if there's any doubt as to whether an issue should be arbitrated or not, do you lean towards it going into the court system, or do you go towards arbitration? All the case law says, all doubts have got to be resolved in favor of arbitration. Here, the court was struggling with, well, should it be arbitrated or not, and lean the other way. I think that in of itself is sufficient to say, no, if there's a close question, it has to go to arbitration. The Lowe case, this court's decision in the Lowe case, I think is also important. In that case, the court here pointed out, what's the essential term in dispute? The essential term in the Lowe case was in a purchase agreement which required arbitration. In our case, the essential term in dispute is whether or not compensation has been forfeited as a result of violation of the non-compete. So again, where's the essential term? You could argue the essential terms are in both the non-compete and in the compensation agreement. And I would concede that.
There might be an argument, right, that you really need to read counts 1 and 2 together. I'm not at all certain that's the argument that's made in the brief. But let me ask this, if that was the argument, that you basically have to read counts 1 and 2 together as a unitary claim because they're just tripping the same thing. I mean, is that an argument about whether arbitration should be compelled, or is that an argument about whether counts 1 and counts 2 standing alone are really proper deck actions?
Probably both, and truthfully, because to me, when I look at count 1, I step back. They don't ask for anything except declaratory relief in a vacuum, right? They're not asking for any relief beyond that. But then you look to count 2, and count 2 says, if there was a violation, then no compensation should be paid. So to me, they're tied together. But my point is this: what is this case about? It's avoiding payment of compensation. My client entered into an agreement which said if there's going to be a dispute about compensation, and they entered into it too, that dispute's going to be arbitrated. My client entered into an agreement which says if there's a dispute about you violated the non-compete agreement, then that is going to be litigated in state court. There's no dispute about that. Those two agreements conflict right now. There's no doubt about that as well. But you have the other doctrine about we have a broad arbitration provision. And that broad arbitration provision, based upon the case law, says, well, then you look to what's the relationship of the parties. Let me look at the exact language. The test for determining the arbitrability of a particular claim is whether a significant relationship exists between the claim and the agreement containing the arbitration claim when you have a broad arbitration clause, which we do here. No doubt about that. That language is specifically consistent with all the broad arbitration provisions. The provision upon which they are relying upon to trigger forfeiture is in the compensation agreement. So there's clearly a relationship between the compensation agreement and the claim that they're seeking. So based upon that argument, you end up with, I contend, arbitration. At a minimum, counts 2 and 3 have to be arbitrated. That's our position. I believe it's a closer call as to count 1.
As to count 1, we talked a minute ago about the deck action. Would that be able to stand alone under Chapter 86? Because their Chapter 86 showing for a bona fide dispute doesn't rely anything on the compensation agreement. Their statement, their allegation of bona fide dispute has solely to do with violation of the non-compete clause. Could it stand alone? Is there something missing?
I don't think it can.
Why is that? Why does it not meet Chapter 86?
Because they're not seeking any relief under the compensation agreement.
Why do they have to? Why couldn't they say, listen, we don't know what our remedies are right now, whether we need to seek an injunction to stop whatever the breach is, whether we have independent damages resulting from the breach, but we do know that you're breaching a non-competition agreement, and we're going to get that declaration now, and we may come back and seek supplemental relief later.
Well, back to your point about our counts 2 and 1 being tied together, I mean, I think effectively they are. I think if you look at what's going on here, I understand your point, but what's going on here is not what you're suggesting may be occurring. What they're doing here is attempting to avoid payment of the compensation. There's nothing else in this lawsuit other than avoid payment of the compensation. At the end of the day, that's what this case is about. That's what counts 2 and 3 are. We're not really talking about those.
Yeah, and that just seems to me, I just think you run into that problem with Seifert, which is Seifert says, listen, the mere fact that there is a contractual relationship that ties all of this together and that includes an arbitration provision isn't by itself enough, that the claim needs to involve, you know, kind of construction of some portion of the contract.
Well, but if you look at
count 1 does not require, as pleaded, count 1 does not require that we consider the employment agreement at all.
Do you consider the compensation agreement at all?
Yeah,
Excuse me, right.
Sorry, yes.
Right, okay. And I would agree the way they pled count 1, correct. I'm not disputing that. But my point is as to counts 3 and count 2, we've complied, all the elements of Seifert are clearly met. And if you look at count 3, Your Honor, what they're asking the court to construe is totally the compensation agreement. There's whether or not certain benchmarks were met, event A or event B, has nothing to do with the non-compete agreement. So count 3 is pure compensation. Count 2, after a decision on count 1, is again pure compensation. I mean, if you just look at the style of the case of count 2, declaratory relief as to whether compensation is due pursuant to the compensation agreement, if HEDDEN is in violation of the non-compete agreement. Count 3, declaratory relief as to whether the terms of the compensation agreement have been fulfilled such that compensation is due pursuant to the compensation agreement. Those counts have got to be arbitrated. Count 1, I'll concede, is a closer count. I still think that when you look at the presumption of liberality towards arbitration, and you look at that all doubts must be construed in favor of arbitration, if you're struggling with, does this go to arbitration or does it go to state court, and then you look at where is the forfeiture provision, it's in the compensation agreement. Look at all those doctrines, all those principles, count 1 should also be sent to arbitration.
Don't assume that this is anything other than one guy's musings, but assume we were to say, you know, counts 2 and 3 arbitrable, count 1 non-arbitrable. What do we tell the trial judge to do with counts 2 and 3? Is it send them to arbitration?
Yes,
Is
Your
it
Honor.
stay at pending resolution of count 1? I think your motion asked for both, or is it trial judge, you figure out what to do, and you know, we'll review it if there's an issue that comes out of it later.
We asked that the court compel arbitration of all 3 counts. So if the court were compelled to rule in our favor as to only counts 2 and 3, we would ask the court order that counts 2 and 3 be sent to arbitration. Yes, Your Honor.
Yeah, you mentioned the contention that there is a conflict between the forum selection clause and the non-compete agreement and the arbitration provision in the compensation agreement.
Yes, Your Honor.
But we haven't touched on that argument, whether there actually is a conflict.
Well, if all claims arising out of or relating to the compensation agreement must be arbitrated, and whether or not there's been a forfeiture of the compensation because of breach of the non-compete is a claim under the compensation agreement, my position is that then that claim must be arbitrated. Their position is, no, all claims under the non-compete agreement have got to be litigated. So they're...
But is that what that says? That they all have to be litigated?
Well, what it actually says is if you bring any claim, it says any venue of any action hereunder, that's what it says, shall be solely with the courts in and for Hillsborough County, Florida. I'm reading the language, and that's another point that I made in the brief. Did they really bring a claim under the non-compete? I mean, yes, they brought a deck action, but is it a claim for anything under the non-compete? They're not seeking injunctive relief, they're not seeking damages. So my point is, it's not a claim brought here under. What it is, in fact, an affirmative defense to our claim for compensation. It's not effectively a claim brought under the compensation, under the non-compete agreement, like we're going to seek injunctive relief because you violated or damages of some sort. So if you look at the exact language, I think there's a way you can say you haven't brought a claim under the non-compete, and therefore this claim shouldn't stand in state court.
Mr. Buford, you're at your 15 minutes.
Thank you, Your Honor.
Mr. Lyman.
May it please the court, my name is Chance Lyman, and I'm here with Steve Pratico today, and we represent the appellee, ZOLDCO in this case. I just want to touch on a few points brought up here. First, Judge Atkinson, is there a conflict between these provisions? I don't think so. We have multiple contracts. They have multiple dispute resolution provisions. I mean, whether we're calling them forum selection clauses or dispute resolution provisions, I don't think that makes any difference. And I would also say that appellant conceded pretty much in the motion to compel that the non-compete agreement contains a dispute resolution provision. It contains a provision that requires the dispute to be resolved by the court. And so that's really our primary position here, is that when you have two contracts, they're executed contemporaneously. You do construe them together, but when only one contract contains an arbitration provision and the other doesn't, in fact, when the other contains a different method of dispute resolution, you've got to let the more specific control over the general, and also the contract that contains the arbitration the provision can't be imported into the other contract.
Let's talk about that, the specific controls over the general. Why is the provision that you contend controls more specific than the provision in the compensation agreement? Both are equally specific.
Well, I think its specificity comes in the form of the fact that it's in the non-compete agreement, and by that I'm talking about the dispute resolution.
You're saying they're all one agreement. So you're saying...
You construe them together, but when one contract contains the arbitration provision and the other does not, that's what the court said in Lowe, that doesn't, the arbitration provision can't be imported into the other contract unless there's some kind of specific incorporation or merger in the document. And I would
you want to read them all together, but you don't want to read that general... You want to read them together, but you don't want to read them. You don't want any importation between the two.
Well, no,
even though, would you not concede that this, even the first, if you take the deck action as a whole, this is arising out of the compensation agreement, because the compensation agreement incorporates by reference the non-compete agreement, meaning that, the non-compete agreement. In absence of the forum selection clause in the non-compete agreement, would you agree that this is arbitrable, because it would then arise out of this deck action would be something that arises out of the compensation agreement?
I would not agree for a couple reasons based on provisions in the compensation agreement itself. First of all, the compensation agreement contains a language in section 5.5 that indicates that nothing herein shall be construed to limit or restrict the employer's rights and remedies, as a result of any breach or default of the non-compete obligations. Now, when we look for the definition...
But what right or remedy would be implicated by requiring whatever remedy sought to be adjudicated by an arbitrator?
The right to have your dispute resolved by the court, which is contained in the non-compete agreement.
Right. Well, I was trying to hypothesize if that was not in the non-compete agreement. In other words, if there were no forum selection clause in the non-compete agreement, would you agree that the arbitration provision in the compensation agreement would then encompass this deck action, all counts of the deck action, because they all arise out of or related to the compensation agreement?
I think I understand now. So if we were assuming that there was no dispute resolution provision in the non-compete agreement, I would say there's still two important carve-outs in the compensation agreement itself that would apply to this case. And by that I mean there's certainly a broad arbitration provision in the compensation agreement, but parties regularly are allowed to, well, first of all, nobody's can be forced to arbitrate a claim they didn't agree to arbitrate, and so we have to divine the parties' intentions from the words they used in the contract. And I would point, Your Honor, to two sections in the compensation agreement, without referring to the non-compete agreement, that carve out from the AAA arbitration types of disputes. One is 3.2, that carves out disputes about calculations involving the exit bonus. That carves it out from the AAA arbitration. It says you're supposed to go to a mutually selected accounting firm. I mean, this is a objective in the compensation agreement alone representation by the parties that they did not want to arbitrate. With AAA arbitration, that type of dispute, and I would also...
But apparently you don't go to court with that claim either, right?
Well, I would say this. You certainly, the appellant has moved to compel AAA arbitration per the terms of just Section 6.7. The appellant's not moving to compel any type of accounting arbitration by mutually selected accountants. So really, I just think that's not... They're asking for the wrong relief, and the relief they're asking for is not available to them.
Putting that to the side, let's just talk about count 3 for a minute.
Mm-hmm.
How is count 3 anything other than a claim that wholly arises under the compensation agreement, right? I mean, it looks to me like what that claim is about is whether you've hit the 10th anniversary of the effective date of the agreement, or whether you've got 10 million, and I forget what the metric is, but in any event, has nothing to do with the non-compete.
I would say two things. One, the count 3 does ask whether the terms of the compensation agreement have been fulfilled such that the exit bonus can be paid. Now, explicitly in Section 5.5, the compensation agreement places several conditions on the exit bonus. One is compliance with the non-compete agreement. And our argument is that takes us directly back to the non-compete agreement's more specific forum selection clause, dispute resolution provision, and that alone resolves this controversy. In fact, as the trial court realized...
That's just not the way count 3's pled, right? I mean, paragraph 28 is, I think, clear about what the dispute is, which is whether events A or B have occurred, and that's the dispute you're calling on the court to resolve. I mean, right? In fact, you've pled separate counts related to the non-compete.
That's correct, but I would say that an arbitrator from the AAA, which is what they've asked for, can't resolve any 3 of these counts because they're all going to be conditioned on the same non-compete obligation and its forum selection clause that is contained, in the non-compete agreement. But another reason that count 3 is not arbitrable in the AAA is because of that Section 3.2 language. See, the events you mentioned about the time and the I think it's division pre-tax net income, that's a contractually defined term in Section 3.2, and Section 3.2 explicitly carves out disputes about that calculation, which is what count 3 is asking about, from the AAA general catch-all broad arbitration provision. So I think this is really...
How does that shunt you back into court under the non-compete, just because it carves out from arbitration a separate type of arbitration?
I'm sorry.
Well, I should have just let you finish your point. Go ahead.
I think what would answer your question is that, if the parties can only be compelled to arbitrate disputes that they've agreed to arbitrate. Now, the parties may have agreed to arbitrate a calculation involving the exit bonus under 3.2, but they did not agree to arbitrate that in the AAA. And that's all that the appellant has asked for here. So really, there's no request to arbitrate that dispute per the terms of the compensation agreement that the trial court could have granted. Specifically, the carve-outs here are intentional by the parties. They said exactly what they said. They said the dispute would be resolved by the mutually accountant firm. And that's not in Section 6.7. And the appellant's motion to compel doesn't mention the Section 3.2 at all. They're only asking to compel under 6.7, which is a broad general provision. We have to construe that broad provision. We have to construe the more specific provisions as controlling when they deal with the same subject matter. And by that I mean when they both propose to resolve disputes, like their dispute resolution provisions. So look to the specific dispute resolution provisions when there's a specific type of dispute.
Well, I think, at least where my head may be at, is I don't even think you have to resolve a conflict necessarily with each. I mean, listen, what I don't think I am hearing you say is that count 3 is really within the rubric of the dispute resolution provision in the non-compete agreement or outside the arbitration provision of the compensation agreement. There's just this question as to whether or not this really has to be resolved by an accountant instead of an arbitrator, right?
Well, I would say that because of the language in Section 5.5 that explicitly conditions compliance on the exit bonus with compliance on its terms, that primarily...
That's not the dispute count 3 is asking the court to resolve. Count 3 is asking the court to resolve whether or not the two conditions, the 10-year anniversary or the $10 million in whatever financial metric it was that I can't remember, has occurred, right? I mean, that's what you're saying the dispute is.
That's true.
You could have pled a different claim, but that's not the one that's alleges.
Well, that's true, but it does, the title of the claim is, are the terms fulfilled? And a term of the compensation agreement is itself the non-compete agreement.
Let me ask you this question about count 2. Count 2 in paragraph 25 frames the dispute as follows. There is currently a bona fide dispute between the parties as to whether compensation would be due HEDDEN pursuant to the compensation agreement if HEDDEN is deemed to be found in violation of the non-compete agreement. To my reading, that says, assume a violation of the non-compete agreement. Would this guy be entitled to compensation under the compensation agreement? Why is that not a claim that arises only under the compensation agreement? I mean, you have asked the court to make an assumption. You're not asking it to adjudicate any rights under the non-compete. You're asking it to assume it's done that. How does the compensation agreement work?
Well, I would say that, this is a forfeiture question then at this point. And another carve-out in the compensation agreement itself on its face is that questions about violations of the non-compete that result in forfeiture of the exit bonus are for the courts. And that is in that's talking about if it's section 5.5 again. So if Mr. HEDDEN breaches, he would forfeit the exit bonus. This provision explicitly acknowledges that this is a court question and not a AAA arbitration question, because it provides that upon notice of the breach, and then notice of the breach, dispute, the exit bonus can be withheld pending resolution of the dispute by agreement of the parties or a final non-appealable order of a court of competent jurisdiction. Now, that says pending resolution of the dispute. That's a dispute resolution provision. And it says a court of competent jurisdiction. It doesn't say an arbitration panel. It doesn't say anything else about arbitration. It's a forfeiture question, and the parties explicitly provided in section 5.5 that forfeiture questions go to the court of competent jurisdiction.
Why wouldn't that final order be logically read in connection with the arbitration provision as referring to a final order confirming an arbitration award?
For two reasons. One, it says pending resolution of the dispute. It doesn't say pending, confirmation of the award. That's in section 5.5. So, and it really only gives you two ways to resolve the dispute in 5.5, and that's agreement of the parties and non-appealable order of a court of competent jurisdiction. I really don't think there's any other way to read pending resolution of the dispute by a court order other than the court will resolve the dispute. And the second reason is that the arbitration provision, the broad arbitration provision in 6.7, it already has that language about confirming a court order. So this language would be superfluous if you thought it only meant, if you read it as only meaning the same thing that they're saying in section 6.7. And so it doesn't. It can't mean that. That would not be a reading that gives every term reasonable meaning in this contract. And that's what our reading does. Again, an arbitrator from the AAA cannot resolve any of these claims.
This is going to be a rhetorical question because you can, so I'll admit being embarrassed if I don't remember the answer. In any of the cases cited by the parties, were those opinions construing a contract, not two contracts, but one contract in which there was an arbitration clause and a forum selection clause?
There are cases where there are two types of dispute resolution provisions, and I think that kind of...
Forum selection clause and an arbitration.
So as in like a venue clause and an arbitration provision? Well, I would direct Your Honor to the apartment investment case, and that contained a broad not catch-all, but a broad arising out of or relating to arbitration provision, but it included a carve-out for different dispute to go to a different forum, and so I think that gets
That's not what I'm talking about, and I asked that question because I just thought of this question.
Oh.
And I didn't go back through all the cases, and so I'm going to make a supposition that there aren't any, and I'm going to make a further assumption is that because if there's a contract in which that has a forum selection clause, maybe very close to or just like this one, and an arbitration provision, the way those would logically be read together is that in the event that whatever dispute is at issue is not arbitrated, but rather has to go to a court, the court it goes to is the one in Hillsborough County. Why wouldn't a court logically read these two provisions in that way? That is, you can call it you cited a case that said that a forum selection clause, that an arbitration provision in essence is a forum selection clause, so maybe there are equal weight. But if a trial court, an appellate court encountered a contract in which had these two provisions in it, would there be a latent ambiguity or a patent ambiguity? No. Would you not agree that they would be easily read together to mean that only in the event that there's an actual action or there is actual litigation, that would have to go to the trial court, but rather in all of the circumstances the arbitration provision controls?
I would agree. If that were the facts that we had here, I would agree. If we had just one contract which contained a broad arbitration provision and then a narrow venue clause that spoke only to venue of a court action, I would agree, but I don't think that's what we have here. I think what we have here first are the two contracts where one arbitration provision can't be imported into the other, and I just want to also point out that in section 6.6 of the compensation agreement, it does explicitly say that the non-compete agreement shall expressly survive the execution and delivery of the compensation agreement in accordance with its respective terms. So that is a complete recognition by the party that the non-compete agreement is a separate agreement in accordance with its respective terms. And I would say another point to Your Honor's question is that the dispute resolution provision in the non-compete agreement, it says any litigation and any action hereunder. I mean, the non-compete agreement is the only agreement in this case that contains all the restrictive covenants and all the rights and remedies, and the import of the agreement is that it's protecting a legitimate business interest. And that's really what this complaint is about. I mean, this is about somebody who's violating their non-compete agreement, and we've got an agreement in place that provides exactly what's to happen when that happens, and it says the court's going to resolve that issue. Now, the Chapter 86 gives us the mechanism to ask for the court to tell us that there's been a breach. We certainly allege there's been a violation. We want the court to tell us there's been a breach. The remedies provision of the non-compete agreement explicitly provides for a litany of remedies when there's a breach. So certainly it's contemplating that the question of breach is a court question. And further, we are seeking remedies under the non-compete agreement. We've asked for attorney fees, and that's pursuant to the non-compete agreement. It's an explicit remedy in the non-compete agreement. So the idea that we're not asking for any remedies under the non-compete agreement is inaccurate. And furthermore, the Chapter 86 is what gives us the mechanism to have our rights, which are exclusively in the non-compete agreement, especially in Count 1, construed based on the facts that have happened. I mean, that's just what DEC actions do. And the statute explicitly says that you don't need to. It doesn't matter if you will be seeking further relief or if you could seek further relief. That's a mechanism that gives us the right to have Count 1, Count 2, and Count 3 resolved by the courts via the DEC action. And it's based on the explicit language of the non-compete agreement. I think I had a few other provisions that I just wanted to point out. So in section 5.3, just to direct your honors, that's discussing the exit bonus, and it explicitly provides that the procedure and provisions of section 3.2 shall apply to the resolution of disputes regarding the calculation of the exit bonus. That's another dispute resolution provision, and that's the one I was referring to that would be more applicable for count 3.
Do I understand your argument on that? I mean, because you've got the obvious problem that you're in violation of that provision too, if you're correct that it's applicable. Do I understand your argument on that correctly, which is, listen, it's his motion to compel arbitration. All the court has been asked to decide is whether there is a contractual entitlement to arbitration in this circumstance. He may have a motion to dismiss, but what he doesn't have is a motion to compel arbitration. Is that, in essence, it?
Yes, I would say that certainly the appellant hasn't argued that section 3.2 is somehow, we're in violation of section 3.2, and certainly didn't put that position, didn't put that argument before the trial court. And
no,
so
I don't see the argument, and I could be wrong about this. I see the 3.2 argument in the answer brief. I don't see the kind of forfeiture remedy provision of 5.5 in the answer brief. I may be missing it.
I believe that's in there because I believe they replied to it and argued that the position that they meant that language actually means confirming the arbitration award.
That's entirely possible. I just got so focused in the fight over which general dispute resolution provision confirms that I overlooked it. I just wanted to ask. I'm almost sure we discussed that language in section 5.5, but I don't think I can direct your honor to that page in the brief right now. Don't worry about it. And you're at your 20 minutes.
And at my 20 minutes. Okay, well, thank you very much, and that concludes my argument.
May it please the court?
You got 5 minutes.
Thank you, Your Honor. Just a few comments. With all due respect, I don't think counsel answered your question, Your Honor, as to why count 3 isn't solely a compensation dispute. Any reading of it indicates it solely and completely relates to the compensation agreement. And so I'm just going to leave that alone. Count 2, again, your point that aren't we really assuming if there's a violation of non-compete, then we're asking the court to construe whether compensation is due under the compensation agreement? That's a claim for construction, for declaratory relief under the compensation agreement. Pure and simple. Count 1, they haven't asked for a remedy of forfeiture in count 1 because the non-compete agreement does not provide for the remedy of forfeiture. The remedy of forfeiture is in the compensation agreement. They can't file an action asking for, purely in state court, asking for that remedy because the remedy is in the compensation agreement, and the compensation agreement absolutely requires arbitration. To your point, Judge Atkinson, I didn't find any case law. I looked regarding the spotted pony, whether there was a forum selection clause and an arbitration clause in contradiction like what we have here. I didn't find any cases to answer.
Does our record tell us anything about whether the employer put the bonus money in escrow?
No, Your Honor. There's nothing indicating that, and I have no idea whether they did or didn't, just so you know. As far as the money going into escrow and the argument about the accountant issue, somehow that precludes arbitration. I don't follow it. I don't agree with it. I mean, count 3 is purely a dispute over whether or not compensation is owed based upon event A or event B. Clearly, the compensation agreement provides for arbitration of disputes like that. I don't see any cohesive argument which makes any sense to me regarding that. Everything else I would argue, Judge, is basically re-argument, so I'm going to leave it at that. Thank you, Your Honors.
Thank you very much.
Thank you.